Hello and welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal news from 29th August to 3rd September 2022. In first important news, the Supreme Court has held that the Insolvency and Bankruptcy Code will prevail over the Customs Act once moratorium is declared. In the case of Sundaresh Bhatt, liquidator of IBC Shipyard versus Central Board of Indirect Taxes and Customs, the court has said that once moratorium under IBC is declared either under Section 14 or 33(5), then the custom authorities have only limited jurisdiction to assess the quantum and they cannot take steps to recover the dues. The court has stated that after such an assessment, custom authorities have the option to approach the adjudicating authority to claim the custom dues as an operational debt under IBC. Therefore, IBC would prevail over the Customs Act once moratorium is declared. In second important news, the Supreme Court has held that the 2018 amendment to the Specific Relief Act is prospective in nature. In the case of Katta Sujata Reddy versus Siddham Shetty Infra Projects Private Limited, the court has noted that the 2018 amendment to the Specific Relief Act is prospective and cannot apply to those transactions that took place prior to its coming into force. The court has noted that the 2018 amendment is not a mere procedural enactment. Rather, it had substantive principles built into its working. The court has said that when a substantive law is brought about by amendment, there is no assumption that the same ought to be given retrospective effect. Rather, there is a requirement for the legislature to expressly clarify whether the aforesaid amendments ought to be retrospective or not. In third important news, the Supreme Court has held that arbitrators fixing fee unilaterally violates party autonomy. In the case of Oil and Natural Gas Corporation Limited versus Afcons Gunanusad JV, the Supreme Court has noted that arbitrators do not have the power to unilaterally fix their fees without the consent of the parties. A unilateral determination of fee would violate the principles of party autonomy and the doctrine of the prohibition of in rem suam decisions, that is, the arbitrator cannot be a judge of their own private claim against the parties regarding their remuneration. In fourth important news, the Supreme Court has held that complaint deserves to be quashed under Section 482 of CRPC if no offence is made out. In the case of Violates Limited versus State of Bihar, the court has noted that if no offence is made out by a careful reading of the complaint deserves to be quashed under Section 482 of CRPC. Lastly, the Supreme Court has held that a murder convict cannot be sentenced to less than life imprisonment. In the case of State of Madhya Pradesh versus Nandu, the Supreme Court has held there cannot be any sentence or punishment less than imprisonment for life if an accused is convicted for the offence punishable under Section 302 of IBC. The court has said that the punishment for murder under Section 302 is death or imprisonment for life and fine. Therefore, the minimum sentence provided for the offence under 302 would be imprisonment for life and fine. There cannot be any sentence less than imprisonment for life if an accused is convicted under Section 302 of IBC. With this, we have come to the end of our weekly legal update. If you like this video, please like and share and subscribe to our YouTube channel.